Welcome to Legal Consolidated. We're going to be building and looking at companies today. There are three types of companies: proprietary limited, which we're going to build, a no liability, such as a mining company listing on the stock exchange, and a public company such as BHP that is also listed on the stock exchange. 99% of all companies built in Australia are proprietary limited companies, little PLs, proprietary limited. There are four major types of companies, proprietary limited companies. The first is a general company. The next is a special purpose company, which will be as trustee of your self-managed super fund. The third one is a company that will be as trustee of your family trust or of your unit trust. And finally, there's a bucket company, and that's a beneficiary of your family trust, because companies pay tax at a lower rate than humans often do. Before we press the big green button to start the document, the building the company, you can see a sample of the documents there, of the full document. And also you can see a checklist. These are the questions which will be asked through the building process. Firstly, a company. Let's have a look at the nature of a company. There are some different purposes for a company. The companies are controlled by ASIC, and we have a direct link with ASIC that allows us to build companies almost immediately. There are certain rules as to what you can call your company. You can't suggest that the company name, like for example I mentioned BHP, you can't have a company called BHP because already a company similar to that, and we don't want to be passing off or trying to pretend we're BHP or Rio Tinto or another competitor, Wagga panel beaters. And you can't have Wagga panel beaters because there's already a company registered under that name. So you can't have things that are similar. And you can we'll do a search of the company name. You can see whether someone else is using it. You can't use an expression which suggests that you are a bank or that you are a trust, because a trust is something different. A company's a company, a trust is a trust. You can't suggest you're a member of the royal family, and you can't use the word incorporated. But the things you can use are abbreviations such as the ampersand. Company can be truncated down to company or COY. Proprietary can be reduced to PTY, limited to LTD, Australian to Australia, and proprietary limited, which is the most common, proprietary limited, PTY, LTD. You are building a company on a law firm's website, and therefore you will receive, as part of the document, a company constitution. Now, company constitutions can only be prepared by a law firm. So if someone's preparing a company constitution and they're not a law firm, that is a very strange situation. I wonder who's carrying the insurance or how they're illegally creating a legal document. The other way to form a company is to go to ASIC directly, and you can build a company with them, but you don't get a company constitution, and it's quite complex. You do get replaceable rules, but replaceable rules can't be used for many different types of purposes, such as you couldn't use that company to be trustee of a self-managed super fund, could be against the law. With the companies, whether you build a company as trustee of a family trust, a company as trustee of a unit trust, a company as trustee of a self-managed super fund, or a bucket company, or a company itself to run its own business, you will always receive the cost includes the ASIC corporation fees. The certificate of incorporation you'll be provided, and you'll also get an Australian company number, 9 digits. As with all our documents, you'll get a cover letter confirming that our law firm prepared the company and the company constitution. And we'll also show you how for free to get an Australian business number, a tax file number, or register for GST if you need to, but you should talk to your accountant about whether you need to do that or not. A trustee of a family trust would probably not have an Australian business number, probably not have a tax file number, and probably not have GST, because it's the family trust operating, not the company. Our company constitutions always can have Division 7A loans attached to the back of them automatically for the shareholders, have tag-along clauses, share buyback, preemptive rights. They're friendly for auditors. They allow for profit distributions even though there's no profit for ATO purposes. They have many different classes of shares. So if you're a farmer, if you're a cocky and you want to give some shares to your children, you can do so and still keep management control shares. You can have meetings electronically. You no need to have annual meetings anymore. Also, you have a single director company. A lot of companies are still being formed in Australia where 2 directors are required. That law changed decades ago. You get your own share certificates as part of the package that when you build this document, and you get all the required minutes. The company directors and shareholders do not need to sign together. When you do sign, they'll be signed under deed. So that's a human signing clause, and there's a company signing clause. Digital signatures are acceptable under a legal consolidated company constitution. How to maintain a company register can be done electronically, one of the distinct advantages of legal consolidated companies. You can hold shares if the person's under 80, your girlfriend or your child is under 18 years of age. You can hold the shares for them in trust, a bare trust. Now let's have a look at the company to be trustee of a self-managed super fund. This is peculiar because if you do have a company that is a special purpose company, which you can build on our website, then it can only be used to be trustee of a self-managed super fund. And you think, well, gee, Professor Davies, the company's cost a fortune and a lot of money, so I want to use my company for many different purposes. No. If you are running a self-managed super fund, you have a company, only let it do that job. Oh, but Professor Davies, it says under the law the company can wear 2 hats. It could be trustee of my family trust and trustee of my self-managed super fund. True, but it's just a mess and the auditor will not like it. Also, if you decide to register the company as a special purpose company, you pay less ASIC fees. It's its only value. The only value, I'll say it for the second time, the only value of a special purpose company is to have a less expensive yearly ASIC company fee. But if you do opt to have a special purpose company, as I've done, my self-managed super fund has a corporate, has a company, and it's a special purpose company, but I can only use it for that one purpose, to be trustee of a self-managed super fund. Now, the company is trustee of a family trust. That would be if you're running a business through the family trust. It's important to try and distinguish yourself because businesses go insolvent, any business. So you want to try and put a corporate there and less exposure to the risk. And the bucket company, as I said, pays less tax. So let us start building the company. Just press the big green button and I'll have the company, and I can search here. I can click to see whether that name is available, and I can also make it anything I want. Most people opt to have Pty Ltd, but for fun I'm going to make it Proprietary Limited. the place of incorporation doesn't make that much difference, but I'm going to make it Great State of Victoria, because that's Melbourne's got more people than Sydney, apparently. I can't believe it. The proposed company name is identical to an ASIC issued business name. So I've been running a business with a little business name for 20 years. My accountant's now told me to get and put that into a company, and therefore I would press yes and type in the name of the Australian business number. But in this case, I do not have an identical business name. If I've reserved the name, then I will write the reservation number in and the name of the person that owns it, but in this case I don't. Will the new company be 100% owned by another company? So is this a subsidiary? No, it's not. Place of business. Now, what's the place of business? That confuses me. So I need to go check on the right-hand side, and I can see lots of hints. And this is quite a famous thing for Legal Consolidated, and I applaud them for this. There's lots of hints. It's highly educational, the building process. In fact, don't ring us up until you've had a go building the document, because most questions that you'll have will be answered as part of the building process. So, company as trustee of a self-managed super fund, yet another training course. Why is my company in uppercase? You will get, when you get your company, the certificate of incorporation will all be in uppercase, but that's not a requirement that you then have to follow that. You can put it uppercase, lowercase. It's just ASIC being a little bit lazy in not using uppercase and lowercase. Now, why mention the state of incorporation? Has to be born somewhere. It used to be the case that there was stamp duty on the shares in your company, but Queensland abolished that decades ago, and all the other states followed suit. So all they've got left, the states now, is land, and that's why your land tax is so high, and payroll tax for your employees in the state. So the greedy states can no longer clip the ticket on the stamp duty on your shares, because all you do is cross the border into Queensland or whatever. So place of business. Application, reservation names have gone, but there's a training video on that. What is a special purpose company? Training video on that. So let us now work on the place of business. Is the registered address the same as the principal place of business? So principal place of business is where you will be trading from. Now that could be your home if it's an online business or whatever. The registered address might be your accountant's office. So if you get served with a notice from a government regulator, you might prefer it to go to the accountant. Will the company only be used as trustee of a self-managed super fund? If you press yes, that will make it a special purpose company and can use the company for no other purpose. And why would you do that? For only one reason, because you pay less ASIC fees. So I'm going to press no to that. And I've got to say I've got the written consents and what have you. And if there's something strange, you can press some supporting information for a manual review. This is when you've got a made-up word for a proprietary limited company, but normally you'd leave that blank. We will speak to ASIC on your behalf. About 20% of companies are not incorporated straight away. They're incorporated either an hour later or 2 working days later, depending on if ASIC want to audit it. So you might well put in an address that doesn't appear in Google, and ASIC have a list of addresses, and if your address doesn't accord with their list, they'll do a manual review. If the company name is something unusual, like Abaca, whatever that word is I've put in there, then they will do a manual review on that. So I've got the company details of doing well, and note there's a green tick. Now, the green tick is critically important because Legal Consolidated is responsible for this document. It's responsible for your company, and therefore you want to make sure it's correct. The green tick shows that we're happy with the logic flow. If you don't have all green ticks, you will not see the lock and build button. If you do not see green ticks next to each question, you will not see the lock and build button. So I'm going to jump directors and go straight to shareholders, red. The directors in red, there's something not completed there, so I'll go back to directors. How many directors does a company need? A company must have at least one Australian resident director. So if you have a middle name, it's a legal document, you must put in your middle name. So here it's worried that the director home address, first director must live in Australia, is required. So I'm only going to have one director company here because asset protection, it's better to only have one director. But it's coming up here with a warning to say that I've got to have an Australian address. So let's do so. City of birth, Perth will be, let's say it's Hobart. Place of birth is Australia. You don't have to be born in Australia, but a lot of us are not. But you need to have an Australian address and be Australian resident as least to one director. And the birth state will make it my hometown of ACT. Will the director be a shareholder? Well, what's the difference between a shareholder and a director? Oh God, I hope there's a hint on this because I don't know. What is a director? So there it is. It's a human being. You have to have humans run the company. What is a shareholder? They're the people, or a company, because a company can own shares in a company, in another company. The shareholder are the lucky people that own the shares in the company and therefore eventually will gain all the benefits of the underlying assets of the company. They're the clever people. The silly people are the directors. Being a director is not good. Oh no, Professor Davies, my mum said back in the 1980s that being a director is really a wonderful thing. You put it on your curriculum vitae. Rubbish. Being a director is one of the worst things you can ever do. It's high risk. If the company goes down, may not be so when your mum was around in the 1980s, but if a company goes down now, then it's likely that the director will go down with the sinking ship. So you do not want to have a director. We act for an engineering company. They have 7 owners, and the accountant correctly said only one of them should be a director, and they rotated every 3 or 4 years. And as a small compensation, I think too low, but they give that director $50,000 on top of his normal profit drawings and payment. Being a director is bad. And if you need help there, have a look at asset protection. So I'm going to type in to Google the asset protection. And there it is there. Have a read of the legal consolidated information on asset protection. Being a director is bad. It's one of the bad things you can do. So I'm only going to have one director. and in this case, if the husband is the director, his wife will probably be the shareholder. Because if you're following a man of straw, woman of substance, it's a classic asset protection strategy, then you would have the wife owning the good things like shares and the husband owning bad things like being a director. But in this case, I will make the shareholder the husband. 10 shares, ordinary shares of $1 each, and I hold these shares for myself. Maybe you hold them for your wife, for example. But in this instance, I'm going to hold them for myself. I can add another shareholder, I can add another director, but I'm happy with that. I must have at least one director and one shareholder, and I do. James is both a director and a shareholder. I press next. Are there any shareholders? You need at least one shareholder. If no director holds shares, then you must press yes. But my director, James, does, so I can press no. I've got a green tick. But there's lots of hints here. Why are there different classes of shares? So you can issue different classes of shares as you build this document. Does the director hold the shares beneficially? We had a look at that. In this case, James, the director, does. I've got green ticks. I've got many accountants, financial advisors and lawyers that build legal documents on our website may have hundreds of documents each. And so they might well decide to code their file reference. So if their file reference is Brett PKD, my supervisor is Edward Romalski, client number, client reference, then you might leave that in, or you might put the company name in. Select this box if you want the business logo if you want your business logo on the document. Common. Select this box to remove Legal Consolidated's logo from the document. Generally, you wouldn't do that unless you're a lawyer. And select the box, and one of the lawyers will telephone you. So I now have green ticks. I'm doing very well. However, before I can proceed further, I want to take the advantage of looking at the summary to make sure I've got correct spelling for everything. So I've got Abacadabra Proprietary Limited. It's going to be incorporated in the great state of Victoria. Will the new company be 100% owned by another company? No. Place of business will be at that address, and the sole director will be James. Middle name Smith, and there's his address. Again, he doesn't need to be living in, where's the company incorporated? The company's incorporated in Victoria, but he doesn't actually need to live in Victoria, but obviously needs to be an Australian resident, and you want to put an Australian address in. So I'm really happy with that. I'm going to press validating, and it says, congratulations, press lock and build. Legal Consolidated will then start the process to incorporate your new company. So we've done a check, a logic check, to make sure that from the information you gave us, we now have sufficient information to go to ASIC. Maybe the address is wrong. Maybe you put a date of birth that make the person only 5 years old or whatever. That'll get picked up by ASIC, and we will then speak to them, do a manual review, and contact you if we need to change dates of birth or company names. Now I'm going to press lock and build. I'm going to put in my credit card details, and within 4 or 5 minutes, up to 2 days, the company will be created and emailed to you with the certificate of incorporation. So this is a sample here to let you know what the document will look like. It's on the law firm's letterhead. There's the office holder consents. So in this case, young David will sign his life away to say he'll be a director. Also, he will be the consent for Thelma as well. They've opted to have 2 directors. Perhaps they're a self-managed super fund, in which case that changes the rules somewhat. If you're running a self-managed super fund, and this is a company for a self-managed super fund, and you've got 2 members of the self-managed super fund, they have to be the 2 directors, and only 2 directors. If you've got 6 people as members of your self-managed super fund, then all 6 are directors of that company. There's the application for shares for David. How to print the document. All the changes of the law, the current changes to the law of what's required. There's help on whether, and you should speak with your accountant, but that's help on getting your Australian business numbers and what have you. We're not an accounting house, we're a law firm, a tax law firm, but we don't give advice on Australian business numbers and whether you need to register for tax file number. But your accountant will. That's what they do. Bit of advice if the company is going to be a beneficiary of a family trust. And here's the constitution. It's very long. Company constitutions are very long because they have to allow for many different things. There's some rules. You can't have more than 50 people holding shares, or you'll need to upgrade to a limited company from a proprietary limited company. There's a share capital. In this case, the one we drafted had 10 shares of $1 each, so the paid up capital is 10 Australian dollars. How to get rid of, so if you're doing a business transaction, you can change the nature of the shares, you can vary the class rights, you can issue a lot more share certificates, which are at the back of this constitution. Whether shares are held on trust, because it might be the case that the director holds the shares in trust for his wife or for another entity. So the rules in our constitution, our company constitution, well now your company constitution, for children. Preemptive rights. Preemptive rights are interesting. So quite often it might not just be one family membership here. It might be 3 families. They might be running a bakery shop worth $8 or $9 million. They own 6 or 7 of them around the Gold Coast, and they don't really want you to sell your shares or your spouse to sell your shares when you're dead. So you have to offer them back to the other shareholders first. Preemptive rights. Obviously, just a mum and dad company, then it's not irrelevant. That's the procedure of transferring the shares. Again, if you're about to list on the stock exchange or something, there's come along clauses. So that if you're a minority shareholder, you can, or you're a majority shareholder, you can force the others to come with you. And if you're a majority shareholder that's sold, then the minority can say, well, I want to come along, I want to tag along to that as well. Power of attorney in case of death. how to have general meetings, how to have director meetings. Quite easy if there's only one director, but if there's more than one director, then there's the rules there. How to vote with proxies. See, with these you think, gee, Professor Davies, I don't need a lot of this stuff. That's true while you're just a mum and dad, but as the years go by and you die and your spouse die, then your children may take over and may become a complex group of people. So you need these rules. A company can live forever. You will die. Your spouse will die. But the company could go on forever. And so many super funds can go on forever as well. So let's have a look at the end where we got the share certificates. Adoption of the Constitution, which we've just spent a few minutes looking at. These are the share classes, and you can add to them as well. These are the ones that we've been involved in proprietary limited companies since 1988. These are what the accountants like to see, and I think they're correct. Schedule B is the proxy form. So everything you need is here. If there is a proxy required, there's a Division 7A loan agreement, which applies to only shareholders. So if your husband is not a shareholder, he'll have to have his own Division 7A loan agreement. There's a resolution of directors to create the company. Registered office, public office, principal place of business. Resolution of the directors. So the members, it's the same word as shareholders. So shareholders will have meetings, and the director or directors will have their meetings. The shareholder owns the business, owns the shares at least, and the directors operate and do all the hard work. There's no legal requirement that a shareholder necessarily be a director, and there's no requirement that a director has any shares in the company. It might be a case of potentially a Rio Tinto director may have no shares in Rio Tinto but still be a director. There's no requirement. There's your record keeping, the register of members, which change from time to time. Debenture holders, that's if you lend money. If the company borrows money off a lender, then they might take a registered interest over the assets of your company. There's the notification of your public officer. So the Australian Taxation Office requires for all companies that there be a public officer. And that is so the Australian Taxation Office, if they need to contact the company, they know exactly the human being to contact. Not that director, not this person, not your accountant. There will be one human being who is a public officer. In this case, it's the first director of the company, which is, in this case, David Sinclair. And there's the share certificates. $10 shares of $1 each. But this is a blank share certificate for you as well, if you need it. So that is a company, an Australian proprietary limited company. Start building the document. Telephone us anytime. We'll help you with the building process. There are many hints along the way. We've only touched a few of them. And enjoy the free resources of Legal Consolidated.